You've probably seen it happen to someone you know. A man works his entire life, builds something real, leaves a will that he believes is clear, and within 12 months of his death, his family is fractured. Lawyers are billing at $400 an hour. Two siblings who spent every holiday together for 40 years aren't speaking, and a meaningful portion of what he spent decades building is going, not to the people he wanted to have it, but to legal fees, court costs, and the administrative machinery of a contested estate. The American Bar Association estimates that a contested estate spends 3 to 5 years in probate and loses between 10 and 25% of its value to legal and administrative costs. That's not a marginal inefficiency. That's a catastrophic failure of transmission, after a lifetime of successful wealth building. Here's the more disturbing data. In the most comprehensive study of intergenerational wealth transfer ever conducted, a study of 3,250 families by researchers Roy Williams and Vic Preisser, 70% of inherited wealth is gone by the second generation, 90% by the third. And the researchers were explicit. The primary cause is not bad investments. It is family conflict, relational breakdown, and the absence of shared values around money. The wealth survived. The architecture of the family did not. Take 30 seconds and think about this honestly. If you died tomorrow and your estate was distributed as you currently plan, do every one of your heirs understand why you're distributing it the way you are? Not what they're receiving. Why? If the answer is no for even one of them, you have a conflict waiting. And at around minute 12, I'm going to show you the one clause that Jewish wills have included for centuries that virtually eliminates that conflict before it starts. Let me tell you what actually causes inheritance conflict, because it is almost never what it appears to be on the surface. When families fight over estates, the fight looks like money. It presents as money. Attorneys bill it as money. But the research tells a very different story. The 2019 study in the Journal of Financial Planning that examined over 400 family estates found that families who conducted explicit value transfer conversations before the estate was distributed, where heirs understood the intentions and reasoning behind allocation decisions, had 67% lower rates of will contestation and 54% lower rates of post-inheritance family estrangement. 67% from a conversation, not from better legal documents, from a conversation. The mechanism is not complicated once you see it. Estate conflict is not primarily about money. It is about a feeling that heirs almost never say explicitly, but that drives nearly all contested estates. The feeling is, I wasn't included. I didn't understand. I wasn't considered. When heirs feel excluded from the logic of an inheritance decision, even when the decision itself is fair, even when the allocation is generous, they experience it as a judgment, a statement about their value or their standing in the family. And that feeling does not go away in probate court. It intensifies there. Here's the hidden mechanism. Legal documents transfer assets. They do not transfer meaning. A will can specify exactly who receives what. It cannot explain why. It cannot convey what the person who built the wealth actually wanted the wealth to accomplish in the next generation. It cannot address the accumulated emotional history that every family carries. And it is that gap between what the legal document says and what the heirs need to understand that becomes the fuel for conflict. At minute 3, here's the loop I want to open, and we'll return to it at minute 11. There is one specific document that Jewish families have been writing for 3,000 years. A document that has nothing to do with legal structures, nothing to do with asset allocation, and that does more to prevent inheritance conflict than any will ever written. Most people in the Western legal tradition have never heard of it, and yet the research on modern families confirms exactly what this tradition discovered millennia ago. Hold that. Here's the exercise. Think about each of your heirs, your children, your grandchildren, whoever is in your estate plan. For each one, answer this question. Does this person know, in specific terms, what I want this wealth to enable in their life? Not how much they'll receive, what I want them to do with it, what I want it to enable, what I believe about money that I want them to carry forward. If you cannot answer that question for each heir, they certainly cannot answer it either. And that gap is exactly where conflict is born. Here's the immediate insight you can use right now. The moment you can articulate, clearly, what you want each component of your estate to accomplish, not just who receives it, but what it's for, the probability of conflict drops dramatically. Because conflict arises from ambiguity. Clarity forecloses it. In the 12th century in Provence, a rabbi named Judah ibn Tibbon wrote a letter to his son. Not a legal document, a letter. It addressed his son's character, his relationship to scholarship, his treatment of books, his financial habits, his obligations to family. It was specific, personal, and direct. It said not just what the father wanted to give, but what he wanted his son to become. This document is called a tzavaah, from the Hebrew root meaning both to command and to bequeath. It is the Jewish ethical will, and it has been practiced since the biblical period, among the most documented traditions in Jewish life, across every century and every geography where Jewish families have lived. Here's what makes the tzavaah architecturally different from a Western legal will. A legal will answers the question, who gets what? A tzavaah answers the question, why? What values does this wealth represent? What did it cost to build? What should it enable? What should it never be used for? What do I believe about money that I want you to carry forward? And, critically, if disagreements arise among you, here is how I want them resolved. This is the loop 3 I'm opening at minute 6, and we'll close it at 13. Why has the tzavaah been practiced for 3,000 years? What specific function does it perform that legal documents cannot? Hold that. Here is level 1, what you can do today. Write what I'll call a values declaration. It is not a legal document. It is a letter. 1 to 2 pages. Address it to your heirs collectively or individually, whichever feels right, and answer these 4 questions in it. First, what do I believe about money? Where it comes from, what it's for, what it should never be treated as. Second, what did it cost me to build this? Not financially, but in terms of choices, sacrifices, and time. Third, what do I hope this wealth enables you to do that you couldn't do otherwise? And fourth, what would I consider a betrayal of what I built? Those 4 questions, answered honestly, transfer something that no legal document can transfer. They transfer a framework. And it is the absence of that framework, not the absence of a proper will, that causes inheritance conflict. Now let me tell you about a pattern interrupt that changes how most people think about this. In the Williams and Preisser study of 3,250 families, the one that found 70% of inherited wealth gone by the second generation, the researchers asked the families in the study what they attributed the wealth loss to. The families themselves said, beneficiaries weren't prepared. Communication and trust within the family had broken down. The family had no shared mission or purpose. Not one family said, we had bad investments. Not one said, the markets were against us. The wealth was there. The architecture of the family was not. The families whose wealth survived to the 3rd generation and beyond, and there were such families in the study, shared one structural characteristic. They had explicit, documented conversations about values and purpose around wealth, held while the wealth creator was still alive. The document didn't matter. The conversation did. Here is level 2 of the system. Beyond writing your values declaration, hold what I call a family council. This is not a meeting with your estate attorney. It is a family meeting, your heirs present, together or individually, where you share your intentions. Not the legal details, the intentions, the why. And you invite them to respond, to ask questions, to understand. A 2022 Fidelity survey found that only 18% of Americans had discussed financial expectations with aging parents, despite 72% expecting to need to support them. The gap between those numbers is where inheritance conflict incubates. The family council closes it. At minute 3, I promised you the document that Jewish families have used for 3,000 years to prevent inheritance conflict, and told you most people in the Western legal tradition have never heard of it. Here it is, in full. The tzavaah, the ethical will, has 4 structural components. The values declaration I described, what you believe about money. The intentions explanation, why you made the specific allocation decisions you made. The conflict protocol, if disagreements arise, here is how I want them resolved. And critically, a named mediator, a specific person identified by name who the family has agreed to consult before any legal action. And the legacy vision. What do I want this wealth to enable in the next generation? Not spend, enable. That third component, the named conflict mediator, is the one clause that the Williams and Preisser research confirms is the single biggest trigger reducer for estate conflict. When heirs know in advance how disagreements will be handled, they are dramatically less likely to immediately escalate to legal action. Because legal action, in most contested estates, is not the first choice. It is what happens when people don't know what else to do. Here is level 3, the complete architecture. Once you've written your values declaration and held your family council, complete the full tzavaah. Write all 4 components. Have it witnessed, not legally but personally, by the people who will carry it forward. And then do one more thing. Review it annually. Because values evolve, intentions clarify, the family changes. The tzavaah that captures who you are at 65 may need updating at 75. The tradition never treated the ethical will as a one-time document. It was a living conversation, one that continued as long as the writer was able to continue it. Now, let me close the loop I opened at minute 6. Why has the tzavaah been practiced for 3,000 years? Because legal documents alone have never been sufficient. They have not been sufficient for 3,000 years of Jewish life, and they are not sufficient now. The legal document addresses what happens to your assets. The tzavaah addresses what happens to your family. Those are different problems. And a family that dissolves in conflict after an estate transfer is a family where the wealth creator solved only the first problem and left the second one entirely to chance. 1 year from now, if you write your values declaration this month, hold one family council this year, and commit to the annual review, your heirs will know something most heirs never know. Not just what they're receiving, but why. And that knowledge is what converts a transfer of assets into a transfer of legacy. At the beginning, I asked whether your heirs know why you're distributing your estate the way you are. I want you to sit with that question differently now. It is not a legal question. It is not even primarily a financial question. It is a relational question. And the answer to it, the specific, documented, conversation-based answer, is the difference between a transfer of assets and a transfer of legacy. The tzavaah doesn't replace a will. It makes the will unnecessary to contest. Because when heirs understand the why, the what becomes acceptable, even when it isn't what they would have chosen. That is the system Jewish grandparents have used for 3 millennia to pass wealth without lawyers and without family wars. The next video in this series addresses something that most people watching this have never thought about carefully. What happens to your retirement security when the pension systems and government programs you've been counting on don't deliver what they promised? Jewish communities solved this problem 2,000 years before governments invented the pension. The architecture they built is more reliable than anything a government has designed, and it's still available. That's the next conversation.